So, thank you for joining us today. Basically, it's a question and answer session today. So we're going to just sort of the first few minutes, obviously, while we're getting a few people coming in, just introduce everything. Then Chris is going to, mainly as a sort of kickstart into some of the questions later, just do a sort of about a 10-15 minute short presentations, not our usual length, just on some sort of the key points that's going on at the moment. Obviously, it's a fast changing situation with more updated guidance only coming through last night on the extended furlough scheme, for example. So he's going to do that. We have kindly had some questions in already from several people. Some of them the same sort of question in different ways. So we will be able to then go on to the question and answer session, deal with those questions, and then, as I say, it will be open to everyone else to come in, and you can either unmute and ask a question, or you can put it in the chat box. Jenny's going to keep an eye on that and let us know, so we can sort of say whoever it is can unmute and come in. That might be a way to do it as well. So I think it's 25 to. What do you think, Chris? Shall we
yeah,
start
I think we might as well. Yeah.
Okay, so I'm going to hand over to Chris now. As I say, he's got a couple of slides and a little introduction on what's going on at the moment. So over to you, Chris.
Great, thanks, Phil. Okay, thank you everybody for joining us, and good morning. I think what I really wanted to start with doing was just have a little bit of a quick look back at where we've been this year. It's not necessarily a review. We'd normally do that in our first session for 2021, but I think it's fair to say that 2020 has been a very strange year for all of us. I think it's required those of us who've been in employment law, in HR, dealing with people on the front line, especially during COVID, to adapt incredibly quickly to what have been some complicated changes, and changes in particularly the legislation that came through that didn't really match with anything that we knew before. So talking first about the obvious, COVID has obviously defined this year for us. I don't know how many of you saw my recent LinkedIn update. I've just celebrated my first year with Friends. But I said in there that if you told me on the 4th of November 2019 when I started what 2020 was going to be like, I would not have believed you. I don't think any of us would have believed that a large number of people would have been being paid to be at home for 3 months, 80% of their salary, and not do any work, and being paid that by the government. That just sounds mad. Obviously, we knew in November that the virus existed, but I don't think any of us expected it to have the level of impact that it's had. Certainly not that we'd go back into a second lockdown a year later. As we all know, therefore, I've just mentioned lockdown by March. That's sort of the territory that we were in. And of course, April, the economy's pretty much shut down. And the government does introduce the furlough scheme that we were all familiar with. I say we're all familiar with it. We're all familiar with it 6 months later. At the time, it was such an alien concept to us. We didn't know what this was. But I think saying that, it was more procedurally and administratively problematic than necessarily legally. I think we all understood the basic concept. People were going home and being paid by the government to do that. Moving forward, we came into June, we came into July, the economy starts to open again, and where it started to get a bit more complicated for all of us, I think, was flexible furlough. The associated complications that brought, and all of those questions that we were asking ourselves then and trying to make sense of. How do we deal with staff on flexible or irregular hours anyway? What about staff who are earning different rates of pay for different types of work, different rates of pay depending on the hours they're working? And the big one, I think, was how do we work out a week's pay for holiday and redundancy? For a long time, as lawyers, we were all saying be very, very careful, pay 100%. Quite understandably, businesses were saying, no, we want to pay 80%. And it took a long time, obviously, for the government to introduce some nice complicated regulations to tell us what we all suspected anyway, that it should probably have been at the full rate of pay. Then finally, we get what we thought was some good news. Furlough will absolutely end at the end of October. There's no way the economy can sustain it anymore. It's not going to be extended in any way, shape or form. And we were all building towards what was basically now 2 weeks ago on Friday, that last working day of the furlough scheme. until 5 o'clock that afternoon, when we're told that it's actually going to be extended, and it's going to be extended till March, and we're all going to be locked down for this month anyway. And that's kind of where we are now, lockdown 2. We're a week in. Wales have just finished their firebreaker lockdown. Scotland and Northern Ireland are doing whatever it is they're doing. And we're back on this furlough at 80%, and non-essential businesses are all but closed again. What that means is that until about 7 o'clock last night, this was really difficult from an update point of view. And from the purposes of this presentation anyway, I'm not going to talk about what was introduced last night or any of the particular details about furlough under the new system, as it were, because that's what our questions are all about, and that's much more interesting to do as a discussion later. So I think basically, though, we're back to where we were pretty much in August, but with the cap back at 80%. Flexible furlough exists. We're in lockdown, but as I say, from a really basic update point of view, it's where we were and it's what we're familiar with. Just the last couple of points on those slides, really. Again, I'm not going to go into them in detail. We all know there's been waves of redundancies that have been difficult for all of us to deal with, and now the added complication with the furlough updates, which we'll come on to later. We've obviously all had to deal with working from home. Paul and I spent a lot of time on the last couple of these sessions talking about working from home. I know I certainly did. And then sort of the health and safety, the how we deal with COVID. Do we test people? How do we test people? How does that overlap with discrimination law? And the big one, of course, which I can remember talking about now, what feels like forever ago, mental health and well-being in the workplace, which of course has taken a massive knock with furlough and self-isolation. So I think that's probably all I want to cover in terms of furlough and COVID for 2020. What I would just like to do is also move on to where else we've been, because 2020 has also been a normal, for lack of a better word, year for employment law. We've had new statutory provisions, we've had the April updates, and case law and tribunals have carried on, albeit online now, and there are relevant outcomes. So again, just to try and prompt maybe some discussion, as Paul said, just to kickstart any questions that might not necessarily be related to COVID. We've seen parental bereavement pay and leave come in this year after that long and sustained campaign for Jack's Law. It might not immediately feel like the biggest story of the year, and in many ways it wasn't. But as the government was very keen to tell us at the time, it does make us the most generous nation for the very specific and unfortunate circumstances that it applies to. And I think we do also need to bear in mind that compared to the unpaid compassionate leave that existed before, it is quite a major change towards family-friendly rights. The other big thing that happened this year, and again, April feels forever ago now, but April did happen, and we did have the good work plan being updated. I think the big one here is probably that tightening of the Section 1 statements, particularly where it's been extended to written particulars as a day one right, so no kind of hanging around giving it to people a few months later. Now, day one rights for both workers and employees. I do think these updates have been overlooked, quite understandably, because of COVID. I don't know, I'm sure Paul will nod in agreement in a minute. I've certainly seen even updated contracts that are still not containing all of these requirements. The details of working patterns, variable hours and how they vary, probationary periods and how to pass them, and all of the benefits, training, and who pays for that training should all be in these statements now. The couple of probably slightly less interesting and more technical ones in many ways, but Swedish derogation we know ended. The impact that had on probably fairly specific agency worker models in some cases. If people weren't familiar with Swedish derogation before April, then it's going to have made no difference to them whatsoever. This was largely, I think, ostensibly to do with protecting employment rights, obviously for agency workers who are long-term engaged by the same end client. On a vaguely related note, of course, we saw these substantial changes, probably much more significantly, to the treatment of personal service companies through the IR35 tax reform, changes to off-payroll working declarations. Let's not forget that what this did was make it the end client's responsibility to determine an individual's employment status for tax purposes. Reasonably big deal. Current consensus is probably that a determination of unemployment status for tax purposes isn't determinative of employment law rights, but I think it's going to be a very unusual circumstance where somebody is deemed as self-employed for one and an employee or a worker for the other. That is going to be quite rare, I think. Really, this is about drawing out that distinction and really highlighting who is a self-employed consultant and who is not. Last thing I want to talk about before we kind of move into a more open discussion, just a handful of significant cases that have also, well, two that have been fairly well publicised and one that I think passed very, very quietly. I'm not going to look at these in detail because that could wait until we've either maybe got a question about them or perhaps if we do a full case review on some of them next year. The one that most people will be familiar with there are the vegetarianism and veganism debate. And this was really about what amounted to a belief capable of protection under the Equality Act. And what we saw here was a lot of emphasis on the weightiness of the issue, the impact it had on the individual's day-to-day behaviour. I think what we're probably going to see coming out of that in the future is a lot more cases that are going to be decided on that, and a shift in how we necessarily see belief. I think it's going to start to move away from kind of this traditional idea of being a religion as sort of the default description. A lot of us will be familiar with the veganism case. It was very much about, for example, not getting on a bus in case it hits a bird or a beetle or a bug and not being able to do anything about that. It was fairly substantial impact on the individual concerned. More recently then, and just that last one on there, that, as I say, I do think slipped through quietly. I know I did an update on it, but I didn't see very many others. And this is to do with people who identify as gender fluid or non-binary, which I think is going to start to become significantly impactful, I suppose, on the workplace in the same way that sort of gay rights and transgenderism sort of picked up from the 90s into the early 2000s. I think non-binary and gender fluid is going to be the next big sort of gender, sexual orientation, sexual identity issue that we have to deal with. Basically, this case said that yes, somebody who identifies as gender fluid or non-binary is capable of being protected under the Equality Act. It was a big case for, I think, employment lawyers, because if you'd asked us a year ago, we'd have said the wording of the Act made this a problem. Because certainly for the definition of sex, you've got it actually set out in the Act that means man or woman, which of course gender fluid and non-binary gender identities conflict with. Helpfully, what we had was the tribunal here in the first instance say gender is a spectrum. And I think we need to be prepared for the courts, and particularly as society develops in that direction, for similar outcomes in the future. Again, on a vaguely related note and back to belief, the belief that sex and gender are immutable was held not to be protected. So I think we can almost certainly see where the courts are heading with that. I think from my point of view, that's it. I just pulled out what I thought were potentially some interesting things not to do with COVID that we could talk about if people wanted to, but I know fully well the questions are all going to be about the furlough update yesterday. So Paul, unless you've got anything to add to what I've just said, I think we'll move on.
Yeah. Well, all I was going to say, thanks for that, Chris. Yeah, no, all I was going to say is that obviously to just move into the question point of view, but on the April changes, I think it's very important. We did updates on that pretty much this time last year on those forthcoming changes. There was quite a lot of news about them sort of leading up to them, but then of course COVID came in and the lockdown literally just before they were due to go live. And as you said, Chris, we are seeing a lot of employment contracts that do not comply with those changes. So I think people are more aware of the day one right aspect. So I think people are aware that they have to give contracts earlier on, but still not everybody. But actually, the fact that they had to review the contracts and make a few changes to them and additions, I don't think has been done in a lot of cases.
Yeah, no, I certainly had one client who was very surprised when I said I strongly recommend annexing your grievance and disciplinary policies to it. Because that is to all intents and purposes a requirement. Somebody needs to understand that from day one.
Yeah, exactly. So that was an important one. On the actual questions themselves, as I said, we've had a few come in, and we will go through those. They were more than 50% of them were basically the same question in different wording. Oh, thanks, Chris. I meant to say.
Yeah, that's right.
Stop sharing. just letting everyone come in. So yeah, more than 50%, I was saying, of the questions were basically the same thing. And it was all to do with this new aspect of the extended furlough scheme, which is that employers can bring back people who were made redundant after 23rd of September. So as I say, we've had several questions, different aspects about it, but basically about, we're having employees asking, can they come back, or we want to bring some people back, and there are some sort of wrinkles around doing that. So Chris and I have had obviously been talking about that quite a lot, and I'm just going to hand back to Chris. He's going to talk a little bit about that, and I can chip in as well, because we've basically agreed our thoughts, I think, Chris, haven't we?
I hope we did. We'll find out in the next 5 minutes, I suppose,
Yeah.
won't we? Yeah, I suppose the starting point with this, the big question that I think kind of merged together all of the questions that we had in advance was, yes, we're allowed to bring people back. Does that mean we have to? If we're getting pressure from employees that we've made redundant to do so, is there an obligation on us? I think the starting point, yeah, we have the guidance updated yesterday. I don't think it said much that we weren't expecting, and I think we'll come on to maybe some of the slightly quirkier bits in a minute. But what it actually said in relation to bringing people back is that employees who were on payroll on the 23rd of September, so that's the day before the job support scheme was announced, and who were subsequently made redundant or lost their job for basically COVID-related reasons, can be reemployed, and applied for. So the question is, yes, you can, but do you have to? I think my answer really is basically no. It's fundamentally is going to be a business decision as to whether you bring somebody back who has already genuinely been made redundant or not. Again, it actually goes back to what we were saying before about this when we were talking about furlough in earlier sessions. We call it furlough. It's the job retention scheme. If they're going to be redundant anyway at some point, there's actually not much value in stringing that out for somebody. Certainly, if there is a risk that redundancy could take place in December because you suddenly realise that even with furlough, the business still isn't sustainable or the role isn't sustainable. And in particular, if you've got no necessary kind of intention that the job will exist in March or April when the scheme ends anyway. I think in terms of whether that leaves you open to an unfair dismissal claim, my view is it's still unchanged, I think. I can't see a tribunal insisting that somebody should have been placed on furlough as an alternative to redundancy if the role was genuinely redundant. I think it brings too many obligations. I mean, I'm not saying it's not an argument I'd run if I was acting for a claimant, but I think it brings far too many obligations on the employer. You've got people who might acquire additional employment rights as a result of that additional time. You might have somebody who steps into a third, fourth, 20th year of employment, and therefore their redundancy and notice increase in that time. Ultimately, it is going to cost more because part of your planning is going to be sustaining that person as part of the business. And if there's no value in doing so to the business or even to the individual necessarily, why require it? That said, I do think somebody who is being made redundant has probably got a reasonable argument to say that the furlough is an alternative if it is viable to do so. I still think it's pretty weak for the reasons that I've just mentioned. And I think providing that the reason for the redundancy was otherwise fair and that there was a genuine redundancy for that individual role, I really don't see that there's any obligation to you to continue to in any way pay or keep them on your payroll. I think before I go any further, Paul, did you want to comment?
Yeah, no, I was going to say a couple of things. I agree basically with what Chris is saying. The other sort of slightly cynical aspect is the government, of course, if a business, and Rishi Sunak made a big thing about this, about businesses having to be viable going forward. If they don't want employers using furlough money just to basically keep someone on for a few more months if the job is never going to be there.
Yeah.
So if there is a genuine redundancy and you've either already made this person redundant between 23rd of September and the start of the new scheme, or you are going through a redundancy process, the fact that this extended furlough scheme has come into place won't change that, I don't think. And as long as you do it in a fair way, the usual procedures, then you're not going to get you're not going to get too much of an issue. The flip side of that, of course, is if the employee can say, well, actually, the furlough scheme is going through to March at the moment, although it's going to be reviewed in January, and I can show, it'd be difficult for them, but I think I can show that the business is going to be a lot more sustainable by then, and I will be able to be kept on, then you've obviously got to take that into consideration as part of consultation. On the specific point about someone being made redundant after 23rd of September and wanting to come back, the other question we've been asked, and I'll sort of lead into this, and again Chris can chip in, is about redundancy pay, because of course if you've already made them redundant, you've probably paid them, well, you should have paid them their redundancy pay. And we've had the questions about, well, what happens with redundancy pay? And again, I was talking to Chris about this. There's a legal and a practical aspect. Firstly, I think legally that, as Chris has said, you have initially the choice of whether to bring them back or not. If you do bring them back, then of course, technically they're not redundant. And you may know, as part of the new scheme, you can do retrospective furlough back to the 1st of November, as long as you do it by the 13th. So we're only 2 days away now. So by Friday, as long as you've done it by then, you can actually retrospectively furlough them back to the 1st of November. So if, for example, you made a redundancy on the 30th or 31st of October, I say 30th because that was Friday, then you may want to take advantage of that retrospective aspect of it. On the redundancy pay point, my thinking is obviously they're not redundant at the moment anymore, so technically you can ask for the redundancy pay back, and you can make it a condition of bringing them back. You can say, well, we're bringing you back, we will bring you back, but you need to return the redundancy pay either immediately or some sort of deduction of wages, authorise that. Obviously you'd have to put that into writing, but ultimately the answer is, with redundancy pay, yes, you should have paid it. Okay, you might be lucky, and if you've only literally just made them redundant, you might not be paying it until sometime this month in your payroll. But if you have already paid it, I think you can ask for it back. Do you agree, Chris?
Yeah, I think I do, and I think the only other interesting thing about paying redundancy is continuation of employment for the purposes of this as well. It's one of the interesting things that unfortunately wasn't contained in the guidance. It's again, COVID has been fantastic because it keeps cropping up these little areas of employment legislation that we don't normally get to look at. And in this case, it's section 214 of the Employment Rights Act. And what that usually says is that if you have paid somebody redundancy pay, their employment has ended, fine. If you then bring them back, it's not a continuation of that original employment if they've got redundancy pay. So I think what we were kind of hoping is that this guidance would make it clear to us whether, from a legal point of view, what this is the redundancy never happened and you've continued to be employed by us since 30th of October, for example, or we're bringing you back on an entirely new engagement of employment. I think, in my opinion, it's largely going to be the former. The redundancy never happened, pay back your redundancy pay, and your employment just continues. I think that's going to be how this plays out in practice. But I can see certain potential arguments for the other side as well. But again, going back to what we were saying earlier and going back to what we've said all the way through, this is supposed to be about sustaining viable jobs and jobs that are continuing to exist. And again, picking up on what Paul said earlier, if this is about viable jobs, again, what you don't want to do is be the person who keeps everybody on between now and whenever this extended scheme ends, and then make a load of redundancies in, say, March anyway. Yeah, I don't think that you're going to make yourself popular with employees or with HMRC doing that.
Yeah, albeit that's what a lot of businesses, I think, unfortunately have done in October. But yeah, it doesn't look good. Yeah, I agree, Chris, on the contingency point. I think there is a debate if there is a gap. So let's say you literally made them redundant on the 24th of September and brought them back, nearly a month and a half later, there could potentially be an argument. But if you literally only made them redundant last week and then you you bring, sorry, when time flies, on the 11th now, but the 31st of October, and then you bring them back immediately, retrospectively from the 1st of November on furlough, then there is, as part of the law, there is a 1 week gap that you normally have to have for continuity of service anyway, outside of the redundancy provisions. And I think there's an argument there as well, if it's only such a short period. So I'm with Chris on this. I think, unfortunately, it wasn't in the guidance, but no doubt if it is challenged, which it probably will be, then it will be the case that they will say that you have continuity of service. Of course, the government could still clarify it further, because they have said there's more guidance coming out at the end of November. Which brings me on to, I know Chris did say that he wasn't talking about, and we agreed this, that he wasn't talking about the announcement last night because it will probably kick off debate. But there is something about last night's guidance that I do want to raise now, and it may bring up debate, that was quite worrying for employers, because a lot of the guidance last night just confirmed what we already thought, and what Chris said earlier about the scheme is pretty much back to where we were in August. However, there is one important point, I think, that's come out, and the government have said that they are reviewing whether employers can use and basically put people on contractual or statutory notice period and use furlough. And they've said it's going to change from 1st December, and we will get further guidance from late November. That suggests to me that actually they are considering and probably are going to change the current scheme as it was, that you can use furlough pay or furlough grants for the notice element. So you can make someone redundant or indeed dismiss them for some other reason and use furlough pay during the notice period. I think the government may be stopping that from the 1st of December. So I suppose one practical aspect to announce now is that if you are seriously considering giving notice to someone in the very near future, do it before the 1st of December. Is that your understanding as well, Chris?
Yeah, absolutely. And I suppose it goes back to what we were just saying as well. I suppose there's now a question of what's the point of bringing somebody back if you might have to serve notice on them 3 weeks yesterday anyway?
Yeah. Well, but I think it may not just be about bringing people back.
Oh, no, I agree. Yeah.
Everyone on furlough, you won't be able to use use it. So, as I say, we're waiting for updated guidance, which probably the government will do late one evening, just before the 1st of December, because that seems to be like last night was 7-ish, Chris, which is quite early for them. It has been later than that. So we'll say, but I thought I'd get that out there now. So that's something else that could be talked about.
Yep.
We have had a couple of other questions as well that weren't to do with furlough scheme and that. So I'll cover those, and then you'll be pleased to know, maybe, that we'll open up to general questions and debate from you guys. So first question, and I won't say, I haven't said who these questions have come from. People can say if they want to, but it said, could you please clarify whether someone with a 0 hours contract should usually be treated as a worker with the associated rights as opposed to an employee? Now, before I answer that, actually, I was just thinking, Jenny, you might know, can we do like a poll on this? We probably can't, can we? I was going to say, or maybe people can put, a lot of people haven't got the video on. I was going to say, put your hands up. Who thinks worker, who thinks employee, who thinks depends. But a lot of people haven't got the video on, understandably, so I can't do that. Anyway, that was just a thought. But the answer is it depends. Because at the end of the day, 0 hours is just one aspect of the contract. The reality is whether there is, the mutual obligations that you need to be an employee. So you can have someone on a 0 hours contract, and a lot of retail fast food chains that would do this, where they have someone on a 0 hours contract, but with students, for example, but there's no obligation to take work at all, and the work's quite infrequent. Maybe it's in the holiday period, Christmas time, summer holidays, and that. And but the students, as it often is, can freely say, no, I don't want to work for the next couple of weeks or next month. And those sort of contracts are much more likely to be worker contracts. Okay. However, I see actually, interestingly, a lot of 0-hour contracts, and indeed I've drafted them, that are employee contracts. And that's because the employer wants some control. They do want to, whilst they can't guarantee the amount of hours that are going to be worked, they do want some control over the employee. And there's going to be fairly regular work as well, because that's the other thing. What happens in practice, the contract can say what it likes, but if the person is actually in practice working for you every week, or certainly on a regular basis, then there's going to be much more argument for an employee contract. And what you've got to consider is that ultimately, are you making them a worker purely just to avoid employee rights? If the answer is yes, then that's quite dangerous, because in a lot of 0-hour contract situations, I see the reality is that it's an employee relationship. It's just the employer has badged it as a worker relationship. So it's not an easy answer in some ways, because it really comes down to the practicalities of how the person is going to work for you. As I say, you might be surprised that I see more employee 0-hour contracts than I do worker ones, but that's probably because I'm not instructed by McDonald's and Burger King and people like that, who I suspect use much more worker ones. What are your thoughts, Chris?
Yeah, I don't think I've really got much to add to that. I think the important thing, whether it's 0 hours or not, to be honest, is make the decision about how somebody is going to be treated by you for employment rights purposes, and treat them in that way. If you want somebody to be a worker, know what that means and make sure that you're only treating them as a worker, in the same way that we would say in the distinction between employee worker and self-employed consultants, I suppose.
Yes, yeah, that's right. Yeah, so it's really analysis. If you're putting someone on a 0 hours contract, it is the analysis of what's the working relationship going to be. If you're in doubt, the safest thing, obviously they're getting rights, but the safest thing is put them on an employee one. But then of course they get holiday rights whether they're a worker or an employee anyway. So it's only really unfair dismissal rights and redundancy. So it's not too much more if to put them on an employee one and cover yourself and know you've got them an employee contract. So yeah, so that's that one. And then the other question we got was, could you please clarify whether loss of a job through a business reorganisation would usually satisfy the legal definition of redundancy, i.e. the reduction or cessation in the requirement of work of a particular type? Okay. Business reorganisations will often be redundancies. Okay, so if you are reorganising your business and it involves a reduction in the amount of employees you need of a particular kind in certain areas, so looking at our sector, for example, we need less secretaries or we need less fee earners in a particular department as part of that reorganisation, then it will satisfy the redundancy definition, and therefore will be a redundancy process. However, some business reorganisations won't be a redundancy situation, but nevertheless it might result in someone having to be dismissed, i.e. you don't need that person, but it's not a redundancy situation. So it might be that it's a reorganisation that doesn't involve a reduction in the amount of people required, but that maybe roles are changing, people's skills required are changing, and there might be someone who just won't fit into the new reorganisation. If that's the case, then you can potentially still dismiss them using SOSR, some other substantial reason. And actually, we always, as lawyers, normally when we are drafting responses to cases, if we have been advising the client hopefully beforehand, we would always argue as an alternative some other substantial reason to redundancy, because if there is any doubt, try whether there's a redundancy situation. If the employer argues, well, in the alternative, we still think it's some other substantial reason, tribunals have been known often to accept that, and you will still successfully defend any case. So the answer is, I would say, again, I'll let Chris comment in a moment, the most business reorganisations will involve redundancies, but not always. and as a practical element, always consider SOSR as an alternative. What's your thoughts, Chris?
Yeah, no, absolutely inclined to agree on that. I think looking at it from an employee perspective also makes this one quite interesting. As Paul said, as the employer defending that case, you've got, yes, it was a redundancy, or even if it wasn't, it was an SOSR dismissal. The difficulty, and I've actually got it at the moment in a situation I'm working on, as the employee and potential claimants in this case, is it's very, very difficult to argue you made me redundant in a redundancy situation, but you also dismissed me when there wasn't a redundancy situation. And you know, from a claimant's point, I think this is one of the few areas where it very much falls on the employer's side here if it ends up in tribunal, because you do have more options, even if maybe you've got it, maybe if you've got it wrong in the first instance.
Yes, that's exactly right. Yeah, yeah. You would use the SOSR as an alternative. So that's, as I say, the vast majority of questions we had were all around the bringing people back, and obviously we may have created some more issues about that. We have got a couple of other things that we can talk about. The dreaded B word we've got lined up in case we don't get enough questions, but I think it's now time to open up to questions and debate. So you can either come off mute and ask a question, or if you're a bit shy, you can put it in the chat box, and we can take it from there. So, any questions?
We've had a couple come through on chat.
Oh, right, okay.
Yeah, so one of them is, what can an employer do if you suspect a former employee has breached a post-termination restriction in a settlement agreement and the payment has been made? The employee left last week and payment was made last week.
Interesting. Right, so person's hopefully been dismissed fairly. That's the first thing to say, because in order for you to enforce any post-termination restrictions, there mustn't be a breach of contract. So the first tick box is you have, if you did dismiss them, apologies to whoever it is if they resigned, and obviously it's a different matter, but if you have dismissed them, you have to have done so fairly. But assuming that's the case, if they've breached the restrictions in the settlement agreement, then you can take enforcement action, and it will be possibly getting a lawyer, I would say that, to write a letter to them stating their breaches, and obviously if they're in breach of the settlement agreements particularly, then hopefully you've got a clause in there that says that you can recoup, you can go after them for the settlement monies, and potentially they're causing you further loss by the breach, then you may have other claims there as well, damages, and even an injunction may be needed. What do you think, Chris?
Yeah, I can see a potential debate about whether the post-termination restrictions were new ones that were just contained in the settlement agreement.
Yeah.
Because if that's the case, they would generally require some kind of additional consideration beyond what is being offered. But if that is the case, and there is, it's classic to say we're introducing this confidentiality restriction, this non-compete restriction that wasn't in your employment contract, and we'll give you an extra £100 for agreeing to this. That's sort of the classic format for introducing a new PTR in a settlement agreement.
Yep.
If that's been breached, then of course you've got a fairly clear factual breach of the settlement agreement as a contractual document in its own right.
Yes.
And that should be much easier to enforce than actually trying to enforce the PTR in the first place.
Yeah, that's right. Yeah, but so yeah, it does depend. You see two situations. Often you see settlement agreements that just restate that the employee will be bound by restrictions as set out in clause X of their contract, or as Chris says, it can actually be new PTRs that have only been put in at the settlement agreement stage, in which case consideration should have been given. But in either way, as long as you've got it in the settlement agreement in one of those two forms, then hopefully you can take action. Okay, Jenny, you said there was another.
Another one, yeah. So question on the good work plan. Do the contracts need to include full details of the disciplinary procedure and not just reference where to find the policy?
I'll let Chris do it, because he was at this exact point before we came on this morning. So I'll let Chris do this one.
I'm really glad I said that, because it's still not the clearest part of it. What's my understanding of it is that an employee on day one should understand the disciplinary and grievance policy, know what procedure is followed and what process will be followed in the event that they are disciplined or a grievance needs to be raised by them. obviously, the risk of including it in that statement as a full annex, for example, is that it's then quite obviously deemed a contractual procedure or process. Frankly, grievance and disciplinary procedures are generally treated as contractual anyway, even when they're stated not to be. It's very, very rare for a tribunal to go, oh, your disciplinary procedure, no, that's non-contractual. In my opinion, I'm advising just to annex it, if I'm perfectly honest.
We've always done anyway, haven't we?
Yeah.
We normally do that as it's clearly set out in the contract that disciplinary procedures apply, and they can be found in the SOAP document that is also given, whether it's in the handbook or whether it's as a standalone policy.
Yeah, absolutely.
It's given to the employee at the same time. Yeah.
But no, I don't think it necessarily needs to be, I don't know, clause 24 in the employment contract.
Yeah,
that's not necessary.
No, it doesn't have to be in full in the contract itself. Yeah. Okay. We've had a question. Shared drive. I don't think that's hi. Yeah. Sorry, I thought you were trying to come on just before Jenny's. And thank you for putting in the chat. So it's very clear. As I'll just read it out. As most of our staff are now working from home effectively over the past 6 months, does this now form part of their employment contract? That brings us to working from home policies, doesn't it? Chris's favourite topic.
My favourite topic. I'll let you answer it first then.
Oh, thanks. Can I ask, since you've come off mute, have you done a working from home policy?
No, we're part of Countrywide Group, and they have got a policy, but we tend to have our own sort of more specific policies and we haven't drawn anything up together because we were waiting to see, how things would go with COVID and whether, because a lot of our staff are wanting to work, from home post-COVID.
Going forward, yeah.
And so we're considering it. So we haven't actually got any policies in place formally yet, but some of them are saying, well, doesn't it form part of our contract, as we've been doing this, for a period of time? Well,
that's it. The reason I asked about the policy, because of course that could have been crucial, because your policy could have actually stipulated. For example, we've put a policy in place. So not only have we obviously done one for clients, but we had Chris and I, and it was actually Chris who did a lot of the work on it, or most of the work on it. We did one internally as well for our office manager to then put out to our staff, and we made it very clear in there that ad hoc working from home, and that basically it was by the discretion of the firm, and so therefore it wasn't always it didn't become like a right for the employee to say, well, I've been working from home for 6 months, so therefore it's now custom and practice, and you have to let me work from home. Okay. If you haven't got a policy in place, I don't know what Chris thinks about this. I think there potentially is a risk if this goes on for a long time, that they could turn around and say, and there's practical aspects on it, but I'll come on to, they could turn around. So the legal point is, it's become custom and practice. I've worked from home. You haven't said otherwise. Therefore, I should now be allowed to work from home. On the practical point, if they've demonstrated they're very productive, it's working well and all that sort of thing, that could be a persuasive argument as well that says, well, why do I have to come into the office all the time? I've demonstrated that I can work very well from home. I was in a meeting at work. I did actually go in the office yesterday because I have to go into a partners meeting every now and then to talk about boring things. But funny enough, our senior partner Matthew Fretton was making a comment yesterday how pleasantly surprised again he has been about how productive people have been working from home. Our figures, our what we call our utilization rates, which basically means how many hours we actually charge, has for people working from home apparently is higher than average. So
our productivity has actually gone up.
Yeah, that's what I've seen. Yeah. So there's a practical element to think, well, do you necessarily want to bring them back all the time? Because you may think, well, actually, it works both ways. But on the contractual element, it's best to put a policy in place. 6 months, you could still argue potentially it's temporary, particularly as COVID, it is a specific incident that has happened. And if this vaccine works and it all becomes more like the flu, which we never know, it may do, then you know, you could argue it was just temporary, but I think if you did want to make it, which I think you would, that you as the employer have the power to have the discretion to say, well, yes, you can work from home, you can't work from home, and set out some criteria, then a policy is an absolute must.
Right. So we could bring one in retrospectively then.
Yeah. What do you think, Chris? I think it's still time.
Yeah, I see
always time to
absolutely
bring
no
a
reason.
policy.
Yeah, see no reason why not. I think the important thing here is making it clear that any given period of working from home has been with the company's consent. You know, we are letting you work from home. It's not you've got a right to. If I want you in the office tomorrow, you've got to be here. And that's the point you're making. I think, yeah, what Paul was saying earlier about whether or not this will fall under some kind of common practice, you're going to get into a very complicated
You want to avoid that. You want to avoid that if you can.
Yeah,
So
that's why I thought, yeah, I need to sort this out because, yeah.
So get a policy in place that makes sure the employer's got the power, basically, in terms of discretion.
I might message you about that later.
Yeah, no, we can certainly help you. Yeah, that's great.
Thank you.
Just before I sort of open up for more, Jenny, any more chat ones for you? Because I know you had a couple of, they must have been private ones because I didn't see those.
No, I haven't had any more.
Okay, so any more questions?
Come on, don't make us talk about Brexit, please.
I was going to say, yeah, we can, unless you're desperate for us to talk about Brexit. 5 seconds, otherwise we talk about Brexit.
Well, can I ask a quick
hello,
point? Hello. Sorry, it was me that asked the question about the business restructure redundancy, as you know. Yeah.
As I do.
It was just if that person's specific role there hasn't been a requirement for that role to be reduced, their specific role, if it's that the role has been affected by a restructure that has had some roles reduced in terms of requirement, is it about the specific person's role, or is it about the restructure as a whole and the impact of that?
Right. Well, yeah. I think so. So if someone's specific role isn't going, but you kind of want to get, it sounds like we're into a sort of bumping territory here, which, although not liked by tribunals, is legal. You can do bumping. So it may be that there is still a redundancy situation in place, albeit that person's specific role is still going forward. It isn't being made redundant. It's one of their colleagues. Is that what you're talking? Just to check, is that what you're talking about? Or?
Not really.
That's why. Yeah, I want to check because
I suppose what the scenario I'm thinking about is where at the moment we've got an awful lot of businesses that have got to save money.
Yeah.
They've got to, and in some cases the role isn't completely going, but it could be absorbed by existing roles. So to save the money, the obvious thing to do is to cut up that role into components, because it's an easy one to cut up.
Yeah.
And you can give part of it to one role, part of it to another role, etc., etc.
Yeah.
So the business has got to save money, and therefore it's restructuring. Would you?
So there is a reduction in the amount of people needed, isn't it? Because
there is.
To give an example, and I always use it because it's easy. So let's say I'm an employment lawyer and all the partners, and they decided, right, okay, we want to get rid of Paul, the employment lawyer, because we're all going to do bits of advice on employment law going forward. So obviously, on the one hand, there's the argument there is a redundancy situation because you're reducing numbers. You can see a counter argument potentially, which is, well, the work of a particular kind, i.e. the employment law, isn't diminishing.
Exactly.
That is a classic example where I would use the redundancy and some other substantial reason, because there is a dismissal. It's clear there is a potential fair dismissal there. Okay, you need to cut costs, and you are reducing the workforce by 1 in that example.
Yeah.
So, but the way I would argue, obviously, you would take them through a redundancy. You don't start talking about some other substantial reason to the employee. But when it came to, if they then tried to say, well, I think it's unfair, there's no redundancy because the work of a particular kind hasn't diminished, you still need to do the employment law, then that's where we would say, well, we say it is a redundancy, but if it's not, it's some other.
Okay. Yeah, that was the line I was going to take, and it was treated as a redundancy, and I've done a few of these recently. But essentially, most of them are about businesses having to cut costs.
That's
not
right.
completely lose the
Yeah.
role.
Yeah.
They still need it, but they don't need it to be done as an expensive role on its own. They can
Yeah.
break it down
Yeah.
into its component
Yeah.
parts.
And I think from a layperson sort of, Joe Public, that feels and looks like a redundancy.
Yes.
It's just legally there's an argument to say, oh, is it? So as a legal argument, you use the redundancy SOSR, but certainly practically as HR people, you would do it as a redundancy. Yeah.
Yeah, and I think if you've demonstrated that you've treated that person fairly, gone through consultation, etc., and you've paid them a redundancy payment, you can't really be going too far wrong, can you?
Yeah. Again, it's all about process as well. Yeah. If
Yeah.
you go through a full and proper process, then yeah, you're definitely on the right track to defending any claim. But yes, we do. And the classic one, I get it all the time, probably every week, if not every day. Prospective claimants phone up. I'm being made redundant. It's unfair because I can demonstrate that there's loads of work in what I do. My role is definitely needed. That might be the case, but it might be that the company, their employer needs to do a reorganisation, as you say, to cut costs. Get that all the time. Yeah.
Okay, thank you.
Okay, Chris, anything to add?
No, I don't think so. I think you've pretty much covered that. I mean, you're always going to get the pain in the backside claimant who tries it, and they'll always pay one of us to try it, and we'll always try it. But yeah, I think as long as you're ticking your boxes, and as you say, if you've paid them redundancy and potentially paid them rather than serve their notice, you're greatly diminishing the value of any claim they might have anyway.
Got a question in on chat. Interesting one there. Might hospital pass this one to Chris because immigration.
Oh yeah, my expert area. Thanks.
No. I'll read it out and then we'll talk about it. If someone comes to UK on a dependence visa, can we employ them, or do we need to follow Tier 2 visa obligations regarding recruitment? The dependent's husband is here on a Tier 2 intra-company transfer. Now, bearing in mind the rules are all changing again. I've not looked at it in the last literally weeks. It is changing at the moment. Have you, Chris?
No, not in any significant detail that I'd feel confident.
I think we may have to come back on that one. We'll make a note, and can you, Jenny? Can you sort of copy and paste that? And we will obviously we'll answer the question, but I want to double check because the tiers and everything is all literally changed.
Yeah, it is a great question though. If you've made us think.
Well, that's not difficult for me. Make me most
think
questions
yourself.
make me think. Right. Any other questions? As I say, we've got a couple other things we can talk about, but anything else at this stage? Nope. Right. Chris, shall we talk about the dreaded B word? Because I suppose we are only a month and a half away from.
Well, yes, and
B-Day.
since the Americans got their election result wrong for Boris, didn't they? It's looking like we're suddenly in a bit of a panic more so of a panic about whether we're going to have a no deal or a deal on this one, doesn't it?
Yeah, trade deal suddenly become much more difficult with America.
Yeah.
Right. We have touched on this before, way back when Brexit was all coming through, but now we're really close to it happening. Well, we're already out, obviously, but in terms of the deal, no deal, and it's increasingly looking likely that it's either going to be no deal or a very low threshold deal. We thought we'd just recap on the our crystal ball gazing and what we think is likely to happen, particularly with the current Conservative government going forward. So again, I'll hand over to Chris because he's we've both looked at this a lot before, but he's looked at it again much more recently.
Yeah. I think the starting point is obviously the current legislation allows, in the assumption that we do end up on a no deal, and I think for the purposes of this discussion we're going to assume there will be a no deal because who can predict what will be expected to retain in the event of a deal. any current piece of EU legislation that directly applies to us as the UK can be amended by statutory instrument. So it's going to be the government just going, we're scrapping that, we're introducing that, we're amending that. That is going to be the gist of how this potentially can work moving forwards. So I think what we're probably going to see is certainly some relaxation on the less popular pieces of legislation that regulates employment relationships in the UK. I think a prime example of this will be things like TUPE. I can see a relaxation under TUPE rules. I don't think TUPE is going to go. I think it's still important, obviously, that we have the continuation of an employment relationship in the event of a change in undertaking in that way. I think what you'll see is the consultation being quite significantly relaxed in TUPE transfers, probably more on par with current redundancy consultations, for example. I think the other big one, probably in relation particularly to TUPE, I think in due course we're going to see complete relaxation on the harmonisation rule that almost immediately bring everybody who's coming in onto the same employment terms. I think from a lot of people's point of view, the harmonisation rule as it stands doesn't actually make sense. Okay, find somebody who's been on a more beneficial contract before, yet maybe they should be allowed to retain that. But of course, it's a classic way of causing dispute within the new business. Somebody's being paid more than me to do the same job is a prime dispute that doesn't give rise to any legal claim, unfortunately, but does cause, well, ironically, a lack of harmony in the workplace.
Yeah.
Anything else on TUPE, Phil?
No, I agree that that's pretty much well, we've talked about this, so we're pretty much singing from the same hymn sheet. But yeah, the consultation requirements are like just on TUPE is going, and I almost 99.9% chance I think that's not going to go, because when they did a survey a few years ago, actually to the government, a surprisingly high number of employers said they wanted TUPE to remain in its main sort of guise and form. Whether there's some more tinkering, talk about harmonisation, whether there's some more tinkering around the service provision change elements of it, because that does go over and above the European side of things. So Brexit itself won't change that, but if they look at TUPE again, because that still causes some issues, some practical issues. A common one I get just on that is the old, and linking it to redundancies. The classic, well, we know the buyer is going to make redundancies, but why do we have to wait until after the transfer? Why can't both parties, practically the buyer and seller, make the person redundant before the transfer? Under TUPE currently you can't do that. But yeah, I don't think it's going to be changed that much, to be honest.
No, I think it'd be more procedural than anything else. I just think, as I say, I think harmonisation is the big unpopular part of TUPE more than anything else.
Just interesting what you were saying. Sorry to just jump in. I work for a local authority. Interesting what you're saying about the TUPE and the consulting for redundancy. Obviously, it came in for the local authority that you can. So I wonder if there's going to be some work to try and make it more equitable across organisations, because it is very different for private sector and public sector. So that will just be quite interesting.
Thank you. Yeah.
Yeah, I agree. I can certainly see it, sort of, as you say, being rolled out more widely to balance that out a bit. Okay, unless we've got anything else on complete speculation about TUPE, I'll move on to complete speculation about something else.
Yep.
Okay, I suppose the other unpopular one, working time regulations, everybody's favourite. I think the first thing, we're going to see the 48-hour week go. We've got the opt-out anyway. Almost every well-drafted employment contract has an opt-out provision for the 48-hour week. So I think I can see that going almost whatever happens at some point. It's hugely unpopular with almost everybody, and as I say, most of us have contracted out of it anyway. At the same time, I think what we're going to see is most of the EU, particularly EU case law on this, the calculation of holiday pay is just far, let's be honest, far too complicated. particularly where you've got, there was that classic case of the peripatetic sports teacher wasn't there, and how you work out flexible hours and irregular hours and how they apply to holiday pay. I think we're probably going to see most of that just go, and a complete reset in due course back to the default calculation that's contained in the Employment Rights Act. It may well be that the courts here uphold certain bits and pieces or change definitions and interpretations, but I think you're probably just going to go right back to, let's start with this average calculation and go from there, because that will reset our understanding of holiday pay calculations.
Yes, yeah, I agree.
Yeah,
I was just going to say, obviously,
yeah.
that would be good from the employer's side, because that would do away with adding to the holiday pay in terms of commission and overtime and all that sort of stuff. That will all go if we are right. But as I say, in the current, whatever, not getting into politics, but the current Conservative government, I could see, I agree with Chris. I think it could just be rather than having to try and change the legislation, because we all know the working time regulations is a complete mess, but they almost changing the law back to fit with the regulations almost, than the other way around.
Yeah, just press the reset button, as it were. And of course, the other one that I think will go probably as a result of that as well will be the TICO guidelines. This was the case that said that where you've got peripatetic staff, so for example, care workers who move between residents' homes over the course of their day, that the time that it takes to travel between their own address and the first place at the beginning of the day and the last place and their home address count as working hours. I think that's probably going to go out the window as well, for much the same reason that the 48-hour week will have gone. It actually won't matter if the 48-hour week doesn't exist anymore, but obviously it would also mean that time doesn't necessarily have to be paid.
Yeah, well, yeah, I agree. Obviously, again, it's another sort of, looking from the employee's point of view, that's obviously will be a negative for those workers, because they weren't getting paid for that initial journey in the morning and the one at the end of the day, in a lot of cases. And as Chris said, in this country it's mostly the care sector that's affected. But obviously, if they do away with that, then essentially those employees will lose that time again. Yeah.
I suppose on the plus side for employees, I can't see any pending change to discrimination law. I can't see any government running on a platform of we're going to remove rights in respect of protected characteristics. And I suppose the other big one that almost certainly won't change is current family-friendly rights, because the vast majority of ours are more generous than they have to be under EU law. So I can't see any regression there.
Yeah, the only thing on discrimination is I think they may get rid of the cap. They've talked about they wanted to do it before.
Introduce a cap.
So introduce the cap. Sorry, saying that the wrong way. Introduce cap, like unfair dismissal, where you've obviously got the 1 year's cap or the statutory cap, do pretty much exactly the same for discrimination. Sorry, I said the wrong thing now. I know what I was thinking. So introduce a cap. They wanted to do it before, and the only reason they couldn't is because European legislation forbids them doing that. But once that falls away, then again they could do that.
Yeah, I can potentially see that one probably coming in quite quickly.
Yes. Although we'll come on. I was going to make a comment about the timescales.
Go now.
Yeah. When will all these changes happen? In normal times, they might have happened relatively quickly. With everything going on at the moment, I'm not sure we'll see anything substantial in the next 6 months or so. I think it could be more mid-term than short-term, but that's it. Agency worker regulations, Chris?
Oh, what agency worker regulations? I don't think we're going to have them, because they're just unpopular with everybody, frankly. Nobody likes them. I think they're going to go out the window probably by popular demand more so than by policy. They don't benefit employers, they don't benefit unions, because the only reason anybody who's an agency worker joins a union is to complain about the agency worker regulations. I can just see all of them. Obviously some new legislation under domestic law to regulate the agency working as a structure. So that one may take a little bit longer, but I think basically what we know is the agency worker regulations is probably going to go.
Yeah. I think that's most of what
I mean, again, as I say, we're only sort of speculating and predicting on these. They're just the most likely ones. There's some common consensus within the employment law community about most of these, but obviously all we can do at this stage is guess.
So, oh, it's 25 to 11. I am conscious we probably want to finish by 11 because some, if not all of you, may want to do the remembrance silence. But so we were aiming to finish by 11 anyway, but it's 20, just gone 25 to 11. Any more questions?
Sorry, Paul, just a point of clarification. You have referred to the fact that you expect that we may no longer be able to use furlough pay to pay notice, people who are going to be under notice of redundancy. Correct. From the 1st of December. So anybody who is, I've literally just had an email from a client while you've been talking about the very thing. They have people who are currently under notice and they're due to leave at the end of November. They're asking if they can be furloughed. Would you, bearing in mind what you've just said, is that a reasonable thing to do, would you suggest?
Sorry, so they're actually going to be gone by the end of November?
They're technically supposed to leave the company's employment on the 30th of November.
So the notice between now and 30th of November?
Yes, they're on notice now. Would it be reasonable for the employer to extend that notice and to put them on furlough?
Oh, I see what you're saying. So that's more a question of, because the furlough scheme's in, that's going back to sort of cancelling the redundancy then, is it? And just,
well, no, it's
not cancelling it, but extending
the notice period to allow them to be employed for longer and for the company to use
but with this new announcement, where's the benefit? Where's, you know, that's just going to cost that's just going to cost the company. Yeah. So the answer is with this announcement, you're not going to extend it. You're going to say,
so has that been confirmed now then?
Well,
expecting it
because I sent an email to a client earlier about this, so I'll quote you the exact, because I can get straight to it because I literally wrote it out earlier this morning. The government is reviewing whether employers should be eligible to claim for employees serving contractual or statutory notice periods, and will change the approach for claim periods starting on or after 1st of December 2020, with further guidance published in late November. So what that's basically saying is they are going to make a change.
They're going to, okay, fine.
So, and so we suspect it's going to be either you can't do it or it's going to be drastically limited. So, So,
thank you.
Short answer to your question, is there's no advantage now. So, unfortunately for the employee, and from your client's point of view, just have the notice ended end of November.
Okay, thank you.
Okay. Anybody else? Otherwise, we.
Did you see that one interesting other little point that was in the guidelines about publishing the names of companies and LLPs? That HMRC is now going to publish a list of registered companies and LLPs who make use of the scheme in December onwards. Probably not relevant to anybody really, but just bear in mind that if you don't want the whole world to know that you're using the furlough scheme, don't use it.
Yeah, that's come on from the CJSS, where they said they announced that they were going to do that for the CJSS, and they've obviously thought, oh, that's a great idea. Let's keep it for
some reason.
And but they're bringing it in, as you say, in December. Yes, I did see that. Yeah. Right. Unless I'll give another 10 seconds, unless anyone's got a question. It's 20 to 11, so with I know Zoom calls, we don't like to do them for much more than an hour and a half because they go on. So unless you've got any more questions, we'll call it a day now. And thank you all for attending this morning. Hope it was of use. And obviously you can fire up any questions. We've got that question about the tier system, which I'm probably going to pass over to Chris.
Thanks.
But only because I'm in meetings for the rest of the day, pretty much. But we'll have a look at that. But if you've got any other questions, please let us know. We'll get the recording sort of edited, and we can send it all out. I think we'll probably send it out to all of you as a default, and once it's done. Okay. Right, that's it. Unless I say we'll hang on for a couple of minutes. So if you want to hang on and ask any questions, then please do. But otherwise, again, thank you very much, and see you all soon, hopefully.